that be a surprise to you, Eric?
You came to the first round of golf.
Agree again.
She broke out. But you didn't do anything.
Where you going golfing?
Wherever he's paying.
Haggle Harrington's.
Yeah,
Uh-oh.
honk punk.
That's... Look like Cynthia's flying.
We're on section 11, valuation of damages. I apologize for there not being class the other night, but I was ill and could not make class. So let's talk about valuation of damages. We also have Rule 51 jury instructions, and I'll just talk about that quickly first. We've looked at Rule 52, which is the rule on requests for findings of fact and conclusions of law in jury waived trials or trials in which no jury is available. Rule 51, obviously, instructions to the jury are for jury trials. And Rule 51 puts into play what the law the jury uses in arriving at their decision. It is, in fact, the last words the jury hears. It's done after closing arguments. But you would normally know, you should know, what the jury instructions are going to be, what the court intends to instruct the jury on, because that obviously should tie to your presentation of the case and specifically to your closing argument as you tie the facts to the law with it. Oftentimes we will submit proposed jury instructions to the court. Not oftentimes, you do it as a matter of course, and hopefully you get the court to submit to the jury the instructions that you want, because as we know from studying the law, it can vary depending on what you want the court to actually instruct the jury on. And by that I mean even if we think about negligence, how that would be defined under the law, if we think about the preponderance of evidence standard and what that means, there are a few different instructions on what preponderance means. And so what you want to do is have the jury hear in language that's as easy for them to find for you as possible what the law actually is. So we submit proposed jury instructions to the court, and then what you have to do more importantly under Rule 51 is you have to instruct the court. If they do not give those instructions, you must object, and you must explain to the court why your instructions should have been given. The fact is, if you don't object at the time instructions are given, you have likely waived that right later down the road. Oftentimes, the court will have what they call a charging conference at some point during the course of the trial. Sometimes it's before, sometimes it's during the course of it. It certainly has to, generally, if they're going to have a charging conference at all, before the instructions are given. The charging conference is where the court actually discusses the instructions that they intend to give and whether they intend to give yours or which portions of yours they'll give, what portions of the others and the like. But it's important to remember that this is the point in the process where the jury is going to tie the law to the facts, and you've got to be vigilant to make sure you get the instructions that you want. And if you do not, you need to object. And you know, sometimes at the end of a trial, even a longer one, you're just so damn glad that it's over, and you're going to get word at some point relatively soon, because your work is really done once it goes to the jury, that you sort of let off the gas a little bit. But you cannot, because the fact is, whether your trial took a couple hours or a couple months, this is a crucial time period to make sure that the last words the jury hears are ones that are going to make it easy for them to find for you. So Rule 51 becomes very important. It becomes even more important to recognize that, you know, the court is going to sort of push you and try to say, well, those I more or less said what you asked me to say, didn't I? And the fact is, you've got to be prepared to have a cogent argument as to why more or less isn't good enough, why you want your instruction on preponderance of the evidence, or why you want your instruction on a violation of the law constitutes some evidence of negligence, whatever it is. And you've got to be prepared to be a pain in the neck and insist on it because everyone's trying to put this case to bed, and you just can't be shy at this point, and you can't be one to just sort of go along. The fact is you're probably in the wrong business if you just are the type to go along. At some point, we've got to stand up and take our whacks if that's the way it's going to be. And this is one of those where I've seen lawyers start to take their foot off the gas, or, you know, we've done our work here, let's make it easy, and you just can't. You've got to insist that the court provide the instructions that you need to win. And you've got to have an argument as to why the instruction that you have proffered is the correct one, and why the one the court gave on various issues doesn't go far enough and the like. So the fact is, Rule 51 is going to be one of these later down the road, that if you don't object at the time it's given, the likelihood of surviving on appeal is low. And you know, the fact is, a lot of times, you guys are in law school and you're used to reading cases on appeal, and so you think, well, if I lose in the trial court, I'll just take it on appeal. Or most cases are going to be done at the trial level. The time is over, the expense is over. For the most part, people are done. And if you're lost in the trial court and expect somehow to get a miracle on appeal, that's low too. It's one thing to win in the trial court and then expect to be able to hopefully hold the high ground on appeal. But if you're looking to try and fix something that you should have taken care of in the trial court, the place to do that is in the trial court, and if you don't make your objection there, you don't have a shot on appeal. Yep?
How are jury instructions not uniform? Isn't the same standard for murder applies to every murder case?
Yes, but there are variations on the definition of murder. Listen, not to make light of it, but if I asked you all to write down the definition of murder right now, I'd get 10 different ones, and it's not that complicated, right? Now, some of them would be just wrong, okay? But let's assume that there's a half a dozen that probably are pretty close to accurate. But there's still variations. And the same thing for preponderance of the evidence, right? I tell you that it's a more likely than not standard, that more likely than not, if what the plaintiff's saying is true, the plaintiff wins. But you know, sometimes there's other language where we can make it sound harder than it is. The plaintiff must prove by the fair preponderance of the evidence. What the hell is that? What's the fair preponderance? But it sounds a little more complicated. So I might, if I'm defending, I might want that to make it sound more difficult than it is. I don't want someone saying, all they've got to do is tip the scales ever so slightly in their favor, and they win. But if I'm the plaintiff, I want that one to make it crystal clear as to what the preponderance is, and it isn't a heavy burden whatsoever. And so we could do it, and we could go downstairs and find, even within, you know, model jury instructions, which, by the way, there are books, model jury instructions, okay? And there are there's a bench book where the court, in fact, has, and there's a prosecutor's guide where they have model jury instructions within there. You should be familiar with all of those, because whether you're prosecuting or defending, the likelihood is that you're going to hear those instructions, or you're going to ask that someone's going to ask that those instructions be given. But they're not exclusive, and they're not. While there are a number of uniform ones, even on any given issue, there may be half a dozen different variations of the same thing. And when you look at the reading, and frankly when you hear it, because that's the other part of this, remember, is jury instructions are given orally. And this is all part of the problem with the process that we have is many judges still don't let them take notes. Some judges do. But even if I gave you a lecture on what the law actually is called for the next hour and 15 minutes, and I let you write it all down, you wouldn't get it all. And you're all law students. But that is what we expect juries to be able to do. At some point, hopefully, that will be transcribed and they may have access to it. But it's not going to be immediate, and sometimes the court won't allow the instructions to go in typed like that anyway, because they want them to go by their recollection. If they've got questions, they can come in and ask. So the last part of this process it gets kind of ugly, and it's unfortunate because it's the most important part. You know, I've had cases where we have sort of an agreement on what the instructions are, but then the judge flubs the ball at the end. Oh, did I forget something? Yeah, you forgot something. We had an agreement. You're going to give instructions 7, 12, and 15. And you don't say it like that, because if he's saying, did I forget something? Yeah, you got to give him 7, 12, and 15. That's what we agreed to. We had one, it was a long trial. Court, that's all they had to do, if you think about it, is submit evidence and then worry about the instructions at the end. And the day of the trial, he sort of virtually freelances a very long, complicated federal charge, and then he says during, you know, because he says, okay, let the jury go out, what did I forget? What are your objections? Both questions. He said, and listen, I'm sorry, I left the instructions at home today. It's all you had to worry about for two months, and you can't even remember to bring them, or you don't remember to go back when you realize you didn't have them. This case was a very important case. So we expect the lawyers to do their job, but then at some point the judge has to do the job as well. And part of that is the variation in what the law is. Jonathan was there, and some of the other, Charlie was there, Sandra was there, Mark was there. A lot of you guys are there now, I think of it. Mary, she said today, there's not 100 shades of gray in the law. There's so many more variations than that, and the same thing works for instructions. So, yeah, there's some safety in some of the sort of the uniform charge, but there's also a lot of variation even within that. You know, for instance, it's taken me years to get a good definition of reasonable doubt. There's no way you guys could get it right. I don't think. Does anyone think they have a good definition of reasonable doubt? What that really means? If you had to explain that, and think, if you're trying a criminal case, I need a good instruction on that, right? Do you know the definition? You have it?
The cat in the box.
Oh, the mouse in the box. No, that's a good story for it, but that's not a good definition. That's not a good definition to give to the jury. The cat in the box. No, the
Mouse in the box.
Mouse in the box with the smiling cat, right?
Or something.
Well, at any rate, that's not a definition. And when we talk about reasonable doubt, that is frankly, my guess is that's probably, well, actually, once you have a reasonable definition, it's probably that's the only one you're likely to use that most judges would use. However, my guess is that in at least 10-15% of the cases, they're not getting a good definition of what that is. And obviously, I'm not sure there's anything more important for the jury to get than what reasonable doubt actually means, because it doesn't mean what most lay people think it means. Questions on jury instructions? Let's talk about damages, because this, in civil cases especially, if we're not seeking equitable relief, if we're not seeking declaratory relief, then what we're trying to do at some point is have a jury put a dollar value on what our losses are. And at some point you guys get pretty comfortable with what the law is as to what we have to show for legal liability. But at the end of the day, we have to figure out, well, how are we going to put dollar figures to this that the jury could understand and be able to come back with a reasonable value on what the losses are. And so in Section 11, we're trying to have a better value on what damages look like, how to offer evidence, actual evidence of what the damages are, with hopefully a better ability for the jury to be able to come back and give us the damages that our clients are seeking, and if you're defending, obviously, to undercut the plaintiff's claim of what their losses actually are. The first case is this Blazer Lakeside Industries, and it's a real property case. And so, how would you show the value of losses on real property? Cost to replace it? Is that a value of damages?
You start with the fair market, the the fair market value, right?
Is that it?
Is that,
What's-
no, and then you
Okay,
would,
what's the fair market value? What's that? Let's just define some of these terms.
So we're today,
What it's worth. So fair market value of your real estate is what it's worth, right? Okay, so that's one, well, wait a
The
minute.
thing is that what you will get for it, not what it's worth, because those are two different things.
Okay, well, wait a minute though, so,
The difference between the market value before and the market
appreciation
value.
value, appreciation.
okay, wait a minute. Because because that's what we did start with. Is the property, does it make a difference whether the property is permanently destroyed or is repairable, first of all?
Yeah.
Yeah.
It does. So if the property is repairable, what would be the measure of damages?
Expensive repairs less than the market value.
The expense of the repairs, would you say less than the market?
Value, the measure of damage is the cost of the repairs.
So it would be the cost of repairs. I'm not sure I understand the less than market value. If you say, are you saying if the cost of repairs exceeds market value, then you get market value?
Yeah. If-
Yep.
if-
Yep.
Yeah, if the house is, if the cost of the repairs exceeds the market value, then yeah, they would get the market value.
Then you're limited to market value.
Yeah,
That's right?
as of the rule.
And so that's fair market value or the cost to replace. What about depreciation? Doesn't that factor into this at all or not?
It's the market value before and after the damage.
Right.
So the market value before and after the damage, if it's totally destroyed.
Yep.
But so then, so market value is different than replacement value, right?
yes.
So what's replacement value?
Isn't it what it costs to replace whatever is lost?
So that would be the cost to restore it to that condition it had been in.
Yes.
So replacement value could exceed market value, right?
Possible.
Well, it is possible, right? I mean, I know where the area I grew up in Dorchester, there were these magnificent houses, but my guess, not my guess, to replace some of them would be cost prohibitive these days. I bet we have the same situation in various parts of Lawrence where the cost to replace it would greatly exceed its market value. So if something happens to that person's home or one of my old neighbors' homes, they get market value, they don't get to go back to the home they grew up in? The home they live in? What are you shrugging your shoulders like that for? Yeah, that's it? Sandra, you just sort of shrugged like, yeah. No, is that right? You have to move out of your neighborhood because I move out of the house my kids grew up in because it's too expensive to rebuild it with that beautiful crown molding and all of this stuff? Because no one else will pay for that now?
Not gonna get crown molding.
I'm not getting crown molding if that's what I lost?
I doubt it.
Why? Because it exceeds the market value. So through no fault of an individual's, their house is destroyed. They get, oh, by the way, they're not even getting full market value because they still got a lot of land. You cut that out? Is that right? House on market value, that house, if you had to go buy it, there's one just across the street, looks just like it, 300 grand. But I'm not even getting 300 grand, am I? Because the lot of land has to be worth something, the foundation has to be worth something. You still have those things. So we'll give you 220. That's all I get, even though the cost is $500,000 to replace it. Is that right?
Yes.
It is.
I guess you could sell the land.
Huh? What?
No, I'm saying I guess you could sell the land at the end of the day to make up the
Well,
It's only gonna get 300, because that's what the house across the street's worth if it's exactly the same.
right. So at the end of the day, assuming I can get that for the lot, whatever I can get for the lot comes out of the check I'm going to be getting, because that's not part of my losses. My losses are the market value. Even though this is my house, even though this is my home, that doesn't change it.
Nope.
No. What about this it says replacement cost less depreciation? Because I don't even get replacement costs, do I? Sandra says no again?
Not according to the rule of damages it has here.
Because you didn't have a brand new house with brand new windows and brand new doors and a brand new paint job. You had a used one that had depreciated in value, and not just value in the parts itself that went into it, right?
And your neighborhood could have went down too.
And so all of that affects the damages that I'm ultimately able to recover.
Yeah.
But what does a person do though, like a house that has like all those unique features and they won't pay to restore it because it costs more than what it costs?
Never want the best house in the neighborhood.
that is the rule. Well, let me switch your question around. You know what? I'll give you that house. I'll give you the value of that house in Dorchester or that house in Lawrence, the cost to replace it. And you know what? It's got such beautiful details. I'm going to give you a check for $750. That's what it gets. Now you know you can buy that house across the street, the identical house, built by the same builder, same time period for $300. You really going to rebuild that house, or you're going to pay? You're going to grab the one for $300 and pocket your $450?
I'd probably move.
Huh? Well, but isn't that at least in part is the worry, is there's something economically wasteful about telling someone spend twice or even 3 times the value of the item. And if your damages are what you lost, we can't, it says something later on down the road, we can't give you value for sentiment and the rest of it. If it's an economic situation, what you lost is what you lost. And either it's going to be a market value approach or cost to replace, less depreciation. But cost to replace, less depreciation doesn't necessarily make me whole in a lot of cases. I had a 15-year-old roof, so lifespan might have been another 5 years, so I'm out of pocket on that too. I'm out of pocket on the windows. I'm out of pocket on the appliances. I mean, this is potentially a lot worse. How would you show this value? How would you show market value, by the way?
Yeah.
Say what?
Similar houses.
You could do an appraisal, and with an appraisal, they have 3 different approaches that they look at in appraisals. Either the straight market value approach, the cost of replacement, or the income approach. And a lot of times when you pay for an appraisal, they will use those 3 different bases to show you what the alternatives might well be. And sometimes, obviously, you have the ability to try and use the highest value, although market value is a pretty accepted basis for the loss. The problem comes in these situations where market value is way off from what replacement value might be. In some situations, market value isn't going to get us nearly where we need to be on replacement value. An expert's going to cost you money too, though, right? You're going to have to pay for the appraisal, and like any other expert witness, then once they've been paid, they're subject to being challenged with respect to how they arrived at it and whether they were influenced by the fact that they were paid by the person that they're now going to testify on behalf of. And appraiser will ask you, or will generally ask you, what do you want? You want a high, you want a low, what do you want, right? I mean, well, because it's still opinion, right? I'm not saying you're going to fudge something by hundreds, thousands of dollars, but what are we looking at here, right? And so, listen, I need it to be 6. Can you make it 6? Well, I'll look and I'll get back to you. The fact is we don't hire experts as a general matter until we have some understanding that we have an agreement as to what we're looking at here. Nothing worse, I told you this with evidence, nothing worse than hiring an expert, than finding out he's gonna be used by the other side to prove their point, not mine, and I'm the one that paid the money for this. That's deadly, deadly. So you oftentimes have to know at the outset what we're looking at. Real estate is actually, they're gonna use comparables, they're gonna take a look at the different, and they're gonna make adjustments throughout. A real estate appraisal, when you've seen it, is a full one, is pretty comprehensive. And while you might have some variation, 5, 10, 20, even maybe 30, 40 grand, within reason you can see what it's likely to look at and that it's probably either legit or it's just completely out of bounds. Because that's the thing, is you gotta look at the comps. And if you're using good comps, then it's pretty clear that the finding should be reliable. And if you're using bad comps, then you know that it's not likely to be. Real property, and we've got some other cases that when we come back to this when we look at encroachments and the like, that we also look at damages to real property. But as a general matter, if it's repairable, it's the cost to replace, replacement cost less depreciation. If it is not repairable, it's going to be market value. And I think you've got to recognize I think it's interesting is that this whole notion of depreciation, which we don't really give much thought to, it's what happens, right? You lost a 10-year-old couch. You're getting a 10-year-old couch. You're not getting a brand new one. And I don't know how much you're going to get for that 10-year-old couch.
So, do you still own it at the end? Or does it go, if they have to pay the full value of it?
Well, who has to pay the full value? See, because what we're looking at are cases that go to trial, and you're trying to establish the damages from whoever the third party is. A lot of times when we think about damages and the like, and claims and losses, we're thinking about it from a standpoint of an insurance carrier. And so you're working out some of those details with them. But usually then, certainly for personal property, they're going to take possession of it and they're going to pay you whatever you have an agreement on, assuming you can establish an agreement. When it's something like this, where we're suing someone for the loss to the property, the fact is you're going to have that lot of land. You're still going to have the foundation. You're actually going to have to try and show what the market on that might be, because again, assuming the cost, fair market value, is less than the cost of replacement less depreciation, you're capping out at fair market value. And so if you say fair market value is 3, and you've got say just to make the math easy, a lot of land and a foundation worth 100, then all I owe you for is 2. You still have the lot of land and the foundation under those circumstances, which really, frankly, is kind of a pain in the ass. But that's the problem when you're not dealing with the insurance carrier, where you can say, listen, just give me the check for 3, and you can get 100 for it, God bless you, or you can get more, whatever you want, but I'm done. But when you're dealing with damages, the fact is you've got to take into account what you may end up with, and that has to be offset against what your recovery is likely to be, because that's part of your damages. It's always the plaintiff's obligation to prove both liability and damage. And it's, without speculation. And that's where some of it becomes much harder. Real property is generally one of the easiest things to prove. It's personal property that gets really difficult, as well as, obviously, personal injury type damages where it becomes difficult to measure as well. Go ahead, Jonathan.
So what about when you, going into personal property, when you lose everything that's in the house?
Yep.
How, do you just make a list?
Yes.
Okay.
Right? Yeah, exactly. So let's you lost everything in the house. Yeah, you need to make a list. You need to establish you're going to have to tell me fair market value, right? Which means I need to know the age. and maybe even what you paid for it at the time, but I don't need to know that. I need to know enough that I can identify what its age is and what its likely value is. But here's the problem, think about it, right? Is that, listen, that TV you spent $2,000 for just a few years ago isn't worth $2,000 today, because that TV's $600 at one of these sales, right? And so it gets worse when you start to think about personal property, because that couch that may have a lot of value to you and it's still really comfortable, and or your favorite chair and everything else, someone at Goodwill isn't going to pay $50 for that chair or that couch. And so the value likely is $100. Who's going to pay you for your old sheets, right? What are they worth? Assume you lost everything in your house. A lot of your stuff is worth less, right? To someone else. So how do you establish some market value for your pillow?
They're gonna give you money to go buy used stuff.
Yeah.
Yeah, they are. Yeah, yes, and that's the problem, right? It's replacement cost less depreciation. Who wants to buy stuff that other people have used a lot and now sleep in it, sit in it, and all the rest, right?
I think a lot. It could be brand new. You could have worn a suit once or twice. It's already probably at 50%.
Oh, yeah. All of it is subject to depreciation. And that's where the odd thing comes in, because I'm not being made whole. I could really be killed on a loss that has nothing to do with any liability whatsoever on my part. And the answer is yes. It's going to get worse when we talk about Jim's dog when we look at Krasnecki, right? Because they fall into the same categories, don't they? And so that's the problem is, yeah, Jonathan's going to have to make a list. And what he values as really expensive isn't likely to be at the end of the day. By the way, the same thing works with your insurance carriers. For if you do want to start to look at your own policies and the like, most coverages you can get replacement cost coverage on your insurance policies, which are certainly if you own stuff in your house and a house, you want that, because beyond that you could be at a significant loss in the event of a house fire or some other calamity that occurs at your house through no fault of your own. The fact is, most of your stuff is really not valuable. You could be out tens of thousands of dollars easily. And if the cost to replace your house is significantly increased, as most houses have, if you don't have replacement cost coverage, you're going to get hurt, seriously hurt in the event of a loss. So what about this Campins versus Capels? He's got his IndyCar championship rings.
Yeah.
Trophies. They should be worth something, right?
Well, he put a value on it and he kind of screwed himself.
You think you should put high value?
The judge said he would have got more if he put a higher value.
So he should have valued his own prize as more value.
Yes.
But it certainly was worth more than the sum of its parts.
Yep.
Okay, see, I got two baseballs here. That's my question. I want to know what these baseballs are.
What baseballs are they?
Those are I'm going to tell you in a minute. See, can you see a picture? Those are my two boys who are not little like this at all anymore. So this one, you know who this is? Can you see the St. Louis thing?
Tony La Russa.
Tony La Russa. You know what Tony La Russa's previous claim to fame was? He's no longer managing in the major leagues. The only major league manager who is a lawyer. So he signed, I think it's this one. He signed this ball when we had a great day. One of my favorite days of all time. And this ball, when they were doing a catcher's drill, and man, went up. I think it was Jerry who grabbed it, beat some elderly person to the ball.
What's it worth?
I want you to tell me. I want you to tell me. Okay, that's this one. So this is signed by Tony La Russa, and I have the picture of it showing him sign it. By the way, this lady ruined my picture because she is of no relation to me. But she's in the shot.
Sure, you can crop that up.
Yeah, I know. I should have Mike crop it out for me. Okay, but that's this one. You can tell me what that's worth. But I want to tell you something about that before I do. I want to tell you something about this one. How many of you have ever been to Fenway Park? Okay. How many of you have tried to catch a baseball at Fenway Park? How many of you have done so? Okay, so I caught this one.
Did you really?
Yeah, I did. Caught two. Okay.
Bare-handed, I hope. I hope
No, two hands, and I still juggled it, to be
As
honest
long
with
as
you.
you don't have a glove.
No glove, no glove. I wonder what these are worth. Because like this, I've been going to Fenway Park for a long, long time. And so this is my next favorite.
Quarter at Doug Flutie is pretty easy. He catches one at every game.
I hear that, but it's not, I mean, most of us haven't, some of us have. So what are these worth? Because frankly, I'll tell you, I wouldn't sell this one for anything. I really wouldn't. I'm not even, maybe, no, I was going to say, maybe 10 grand I wouldn't.
Everything's got a number.
I wouldn't. 10 grand, no. This one, I don't know. So what are they worth? Personal property. Because Jim says, like Campins, I should have just put a higher value on it. It's a trophy. This is a trophy. After years of going in the park, finally catching the ball.
They gave his because of blood, sweat, and tears.
Yeah, I don't know.
Blood, sweat, and tears.
Trophy.
Huh?
I don't think it's like a trophy, because, you know.
You don't think it's a trophy?
Well, you
Could have suffered
didn't
physical
play
injury.
baseball, you were just in the stands, you know? It's
Did
more
you ever
like
catch one?
memorabilia.
I
My friend came
didn't.
from Florida, first time ever Fenway, caught a ball, so bad.
And you were a little jealous? Yes. Okay. Charlie, what do you got for me?
$170.
For what? Tony La Russa's? Because you looked up on Sports World or one of those, and they say the market value approach for market value is Tony La Russa signed baseball is $170, right?
Highest baseball has been sold on eBay. That's the way I would put it.
Okay, so you actually went further and said that's the top of the line is $170. Y'all agree to that, or? Because it's not just the fact that his signature's on it is interesting, but it's much more indicative of we had a great day. I can't have that. I ever have that day back with those two, right? So it's a whole bunch of other things that go into it. So, but that's it. It caps out at $170. Because I honestly, God, I wouldn't sell that for 10 grand.
It goes into how often they sign. If he's not a signer, the value goes up.
But that's to other people. They actually don't even care about the pitcher. They don't care about my kids in the pitcher.
No,
Can it have a certain market value to me or to others that is a sort of a specialized market? Because I was wondering, I got rosary beads. Religious items.
From the Vatican?
No, these are actually from, these are actually from the Vatican. I meant to grab a different pair. They're supposed to be from,
Value goes up.
because they're supposed to be from Medjugorje, which they have healing power. Listen, they do. I could give you stories, but I'm not going to right now. And seriously, I've got a couple pairs downstairs. And they're wooden beads like this. $5 grand wouldn't get them from me. And I could tell you stories, but I can see there's a bunch of non-believers, so I'm not going to bother. Just when you get sick, you come see me, and maybe I can help you out. $5 grand, 10 grand, not selling. Could religious items have a separate market value? Because all I got to do is sell it to someone else who will believe me, right? 12 other people who will find that there's a market. Are you saying there's no market value for religious items, Everald? That's what you seem to be saying.
There's a market value, but not a specialized market value.
Why not?
Because the one person who's going to pay 10 grand for one thing is not within the norm of the mainstream of what they're going to pay for it.
Well, why do you have to be norm or mainstream? How many of you own like $200,000 Maseratis? No one in the whole room? So there's no market.
I just sold mine.
So wait a minute. So there's no market for $200,000 Maseratis.
Yes, there is.
Oh, it's a sort of a it's a specialized market for those who really want Maseratis and have the wherewithal to pay for them. Okay, but religious artifacts, no?
But isn't
Yeah.
Maserati more of like, you know, what's the word? It's more common, if you, so to speak.
Yes, I agree.
Yeah. So therefore, it has a wider range of, you know.
A more general acceptance, I'd say,
Yeah.
but there must be some who would find some comfort in religious items. Sandra, right? Right?
Not me, but I know people that would.
I mean, I go to Demoulas and they have a whole couple of big tall aisles of candles. Oh, what do you got? What do you got over there?
I have my scapular.
Okay, so, what?
So how do you get an insurance company to buy into that argument that Jonathan will pay $5,000 for some beads?
What?
I
You tell you that, no.
I'm not trying to sell the insurance company, I've got to sell the jury. Because I do think we need to keep it separate. My brother called me one time, he's a trial lawyer up in Maine, he said, what do I got to do here? There's no insurance carrier for this defendant. So you're gonna have to win your case, and then we're going to figure out how we're going to collect it. We should start looking at that now. The fact is that not every defendant has an insurance carrier, and frankly, they're never going to just open it up and give you everything you'd like. You're going to have to establish the market for that as well. They tried to cheat me out of the value of my Jeep when I totaled it last year. The fact is that's how they make money. That's how they get to be in the big buildings. So we've got to figure out whether there's a market that you can establish for it. And all I've got to do is if it's a small jury, all I've got to get is 6 to 8 people to agree with me. And if it's a larger jury, I need to convince 12 or 14. I say the baseball I caught at Fenway Park's worth $555. What do you say? All those years of going to the ballpark, all those years of paying for tickets. It's rare, it's a trophy. Just like Campins versus Capels. He's getting $750. What was the value of the gold and stuff, right? You have him go make another one. But we didn't make him do that. Blood, sweat, and tears. Blood, sweat, and tears.
But
Go ahead.
Isn't the memory of getting the baseball the real value as opposed to the baseball itself?
Until you steal that memory from me. All right? If the memory is stolen or taken from me, yeah. No? I don't have the right to recover.
I think they're going to say they stole the baseball, they still have the memory.
But it's not the same without the pitcher and this. It isn't, is it? So you're saying, oh no, you get the same. Listen, you don't need the baseball. Have your memories. See ya. That's your defense argument. You haven't lost anything. It's all here. So yes, I know your dad was killed by that drunken driver, but you still have dad here. That's your defense theme. What?
You're not gonna get blood, sweat, and tears.
How do I not get blood, sweat, and tears for this? How many times?
You went to a ballpark enjoying yourself, drinking beers, and you're comparing that to a lifetime of,
Fail the state of claim upon which.
Wait a minute.
Granted.
So you enjoyed yourself by doing this activity, and therefore there's no loss? Because,
blood, sweat, and tears.
geez, I could swear I got a little email from you saying, you worked as hard as you ever worked on anything, but you enjoyed it as much as team
That's not
sports.
blood, sweat, and tears, a baseball game.
Go working all those years trying to catch it?
You weren't trying to, only the pitcher.
Well, yes, it hit in your direction, but you still have to fight for it. Trust me.
How many times you've gone there late and left early when they're blowing them out? And you're like, I want traffic home. I'd rather go to
We're not the type to leave early, as a general matter.
when they stop selling beers in the 70s.
So that's it? $15 for the value of the baseball. Nothing for the blood, sweat, and tears that he says,
Plus your memories.
plus the memories. So what's that mean?
I said $15 plus your memories.
Oh, I get the $15. but that's where it ends.
A pen at Staples and a baseball at Sports Authority, and you're pretty much covered.
And you're gonna do the same for Tony La Russa, except that we can establish a real market value for Tony La Russa.
If you can establish real market value, but
Well, Charles did, which I would think if we went to Sports World or whatever, that sounds a little high, but he said he picked a high price on eBay.
but that's what they're selling it for, not what they're getting paid for,
Well, wait a minute, though, if that's what they're selling it for, that's what I would have to pay for it. That must be my loss.
No, because I could sell that coffee cup for $1 million if nobody buys it, doesn't mean that's what it's worth, somebody's.
I thought he said that was the actual price of the highest one sold.
Yeah, on eBay. Well, no, I think it was just what people are selling for on eBay, but I'm not sure.
He said the highest signed baseball sold was $170.
Oh,
For Tony La Russa.
Any baseball, the highest.
Oh, no,
He said-
we know that's not true.
No.
We don't-
The Mickey Mantle.
That guy.
No.
Oh,
That
for
guy.
him.
Yeah.
Oh,
Yeah, he said for Tony La Russa.
Mickey Mantle.
I think I saw it.
Yeah, he said.
So would I be allowed to present evidence as to what I say the value is? Or are you saying, no, that's that mawkish sentimental value that they're saying you can't get? Throughout his testimony, his feelings for these rings were apparent, but it's not his feelings that he gets to collect for. Personal property, you're going to have to show some level of market value. Fair market value at the time of the loss, fair market value being the price a willing seller will accept from a willing buyer. And so that's what I'm wondering is on, and maybe mine, well, is either one of these, are you saying neither one has any market value beyond my own interest? There's no one else that would share a similar market value for sort of, because I was thinking these were somewhat along the lines of trophies. Go ahead.
Well, how do you show that? Because in one of these footnotes, it says that you can't use your own statement as evidence of, what you wouldn't sell it for.
In Massachusetts, we do have a rule of evidence that, in general, an individual can testify as to what they believe the market value is of their home or personal property belonging to them. So Mass rule is a little different, but your question is, in fairness, your question is a little different. I didn't say the market value was 10. I said I wouldn't sell it for 10. And that's part of the problem is, well, then you're not saying that that's the market value. You can testify as to what you believe the value is, but how is that arrived at? If you're not going to sell it, there may not be a market value. But to me, I want to ask more specifically then about the religious items. There isn't a market?
Yeah, there is.
There is.
Yeah.
My crazy mother would
Yeah.
buy that thing for crazy amounts of money.
Well, can I inquire about that? Your crazy mother would buy things for crazy.
Oh, yeah.
Okay,
She was like, I'd offer you a nickel, she'd offer you like $5,000.
okay, but then there is a market for it. And if it provides some people comfort,
There's a
other people want to do booze and cigars.
That's right.
Right? And so, if that gives them comfort, why isn't there a market then? Well, why can't we establish that the value is more than the sum of its, parts, which is, string and wood?
But the set value too, like using that example, if someone said a Maker's on the rocks at $50, I'd be like, yeah, I'm all set.
But that's because you wouldn't pay. You know what though? If it was 2 a.m. and we had a drink or a cigar, you said $50 for a Maker's and a cigar, and we were celebrating, you would pay it.
No, I wouldn't.
Yes, you would.
No, I wouldn't.
There's people that would though. Like that
Yeah, they
jersey,
got money, I
that
don't.
Boston, that Boston Red Sox jersey that was found underneath the Yankee Stadium. The guy lives near me, paid $2 million for the shirt.
What?
Yeah, because it had been. Okay, but and by the way, there are baseballs where we said there are baseballs that have gone for. One must have exceeded $1 million by now, right, Charlie? So there is a market for, but I don't think it's my Tony La Russa baseball or the one Mike caught. But there is a market. It's going to be slightly different. let me shift to personal property, which is the next case. Well, we still think about these. Let's talk about his dog. He loves his dog. It's a really cute dog. What kind is it?
American Bulldog.
American Bulldog. Like Aaron says, I use cute's an interesting use of the word.
It's like an old man.
He is like an old man.
You're thinking of the English. Mine looks like a huge pit bull.
Not cute.
How much would you sell a dog for?
I wouldn't sell him.
10 grand,
No,
50,
no,
20.
no, but you're getting close.
How old is he?
7.
What's their life expectancy?
Bulldog, about 10.
So he's 7/10 to none. What do they cost new?
Right around, depends where their blood line's from. Like, he's a protection dog, so his line's more expensive.
How much?
Him, probably 1,200.
Something happens to his dog. What's he get?
Depreciation value.
1,200.
That's the cost of a new dog. He doesn't have a new dog.
Yeah, but I have a trained protection dog, which is worth more money.
Okay, so he's got a trained protection dog. Aaron, what were you gonna say?
I was saying that Barry Bonds' 756 home runs sold for $753,000.
Didn't Mark McGuire get close to $1 million?
Mark McGuire's 70th home run ball, 1998, $3 million.
$3 million.
That's the most expensive.
It's all bought by the same guy.
And you won't give me $20? You won't give me money for my baseball with my boys?
That was in 98 too.
After I buy it, look at that, get that.
So wait a minute though.
But that's depreciated now too because of all the steroids.
Yes.
Well, I would think, yeah, that's not. I wouldn't pay $3 million. I wouldn't pay Barry Bonds money either. His dog. It's a straight market value approach, even though he loves that dog like family. So Professor Sullivan's going to be mad at us. The dog's. It is what it is. It's personal property, and if one of you should go in, somehow able to get past the protection dog and hurt him,
That ain't happening.
it's, well, how much is he says it's a trained protection dog. So how much do you get, does he get the value of the training back? Does he get, I mean,
How much-
I'm trying to figure out what his losses are.
Would probably be the cost to train another dog.
The cost to train another dog. So he gets, but he doesn't get a new dog, right? He gets 30% of a new dog,
Right.
which is $400, because he said he's 7 years old, life expectancy of 10, so he gets 30% of a new dog, $400, plus the cost of training. That's it?
I don't think you get the training.
Well, why not though? Because you did lose the training, right? You lost the value of that, of what you paid out for that. Does he get the training or not?
You should, to get
It does, it brings the value up of the property.
Yeah, I think you're absolutely right. Either you're going to get an adjustment on the cost. It's either not 12, like you said. Well, he's a trained protection dog now. I have no idea what that would go for. Do you?
Well, police dogs go for anywhere I train dog, $3,000 to $25,000,
Oh yeah.
depending where they're trained, what they're trained for. Like a drug sniffing and cadaver dogs, they're worth more. So they have police dogs that can do it all that police departments pay $25,000 to $30,000 for.
So either you've got to adjust the value. Say, well, it's not a $1,200 dog anymore. It's say $10,000, just to make the math easy. It's a $10,000 trained dog, but he's 70% depreciated. You get $3,000. Or you could say it's a $1,200 dog, less down to $4,000, plus the cost of training. But that's it. He gets nothing for the emotional loss, nothing for the rest of it. I mean, that's the Krasnecki case here, where they wanted the value, the emotional attachment to the sheep, which is an odd case, obviously.
It would have been better off, they said they were gonna sell it for the wool and meat.
Yeah, exactly, right? But they would chose to make a test case out of the proposition that they wanted to try and show that they would get, that they were losing much more than that. Personal property, unless there's an actual market that you can establish, it's costs less depreciation. But I could show that there are specialized markets for baseball, specialized markets for religious goods, but I've got to show what the market actually is. How many people have to share the market? Like Jim said, you know, his mom, my mom, they have religious items out around the house. That might be a better market. I don't know whether I don't think my mother's going to give me $5,000 for those wooden beads either, though. But how would you prove that? Experts? I'll call an expert in, have the expert testify to this or that. Because that expert's not going to help me with my specialized baseballs, though, either, right?
I guess your son's the expert on that one.
Say what?
I said your son's the expert on that one, I guess that's the best you could do. But
That's the best it's going to get.
as far as the memories are concerned,
Well, everyone said I get to keep my memories. I just lost the baseball, and he'll give me $15 for the
Yeah,
baseball.
You can't count on him.
Huh?
You can't count on him for any emotional judgment. Leave that out.
So are there items that you have that if you lost, it's just we've been lawyers long enough now, though, that, well, that's the way it goes? Okay, so I get my $20, I get my $15, even though you wouldn't have parted with it, and the money won't nearly make you whole as to what you feel the value of your loss is. And there's nothing we can do about that.
the law is. They do that for wrongful death too. Like if you lose a family member, they give you money. You don't want the money, you want the family member back.
But at least we are getting money that is supposed to more likely represent what we've actually lost. I agree with you completely. I agree with you completely. But it seems, I mean, for instance, we'll take Professor Sullivan's point. He'd be devastated if he lost that dog. But we're talking a couple $1,000 if he's lucky. And that's it, though.
Yeah, you'll never
That's the way it
replace
works.
Huh?
that. You'll never replace that dog.
So what if you're a carpenter or a dog trainer and you invest your own time at the expense of not having other clients to improve like your dog or your property and increase the value? Then you've got additional damages, don't you, in terms of what you lost?
You could argue that what you lost is your cost of training it and the like. The problem is, it's going to be harder to establish that you actually did all that, but I don't see any problem if that's what, you know, I know, and he does. I spent the time with this dog. We did this. On Saturdays, we went, I trained him for 8 hours a week for the last 7 years so that he would be better at it. And does he compete?
Yeah, he's won a bunch of tournaments.
And so he takes them to the tournaments, he competes with them. Is that time recoverable? No?
No, I don't believe it's going to be recoverable. I mean, if there's any damage as far as money that he's lost in competitions, like, you know, I stand to win, you know, $5,000 a year or something like that. But what he has chosen, the money that he has chosen to expend, is not recoverable. I mean,
But how is that not, go ahead.
There's an opportunity cost though, because he hasn't accepted other, like he's a professional at it, hasn't accepted other dogs during the time he's been training.
Well, he's not a professional at it.
Yeah, it costs me money.
Hypothetically, if someone is.
You gotta pay to enter these things, and
Do
they
you-
give you a ribbon.
Oh, yeah, I was going to ask,
So it costs.
can you win anything? I mean, win money?
There's a ribbon, first place.
So you didn't lose money. But why couldn't he structure an argument that I want to be paid for my time in training the dog? If I paid, there used to be a guy up here, I remember when we were in Boston, my boss used to bring a dog to Doggy Daddy for training. He was, you know, the dog whisperer back then. If I'm paying someone else, I should be able to recover for the value of that training because the dog's been enhanced. Why, if I'm able to do that myself and I can document and prove what I did and put that training in, why shouldn't I be allowed to present that evidence to the jury as part of my actual losses that I should be able to recover for.
Can't teach an old dog new tricks.
That's one thing.
Gotta appreciate the value more.
What about you?
Oh,
But
my.
the dog was
What-
in shows, even though we trained him, so it should be considered the same as professional trainers.
Well, that, why not? And so he should be able to recover for that as well. I think he can. I think we can recover potentially for more than what, sometimes we look at this and say, no, it's all cut and dry. The fact is, the case talks about if we can establish the market, if we can establish the value of our losses. I don't know whether I'm going to be able to establish a satisfactory market for sort of these specialized memories of my own that attaches to the balls. Charlie's right. At least one thing we know is Tony La Russa's autograph is worth X. So that it helps to establish a market value for it. I don't think the fact that Mick and Jerry are present at the time Tony La Russa signs it is likely to enhance the value of the ball for anyone other than me. And maybe some other dads who might want their little boys to be little again. But I don't know whether we're going to be able to sell that to a jury when one of you destroys my ball or his dog comes in and eats my baseball. I don't know about the pop-up. I think it's $15. And frankly, it was a used ball. A new ball was $15, right? So I'm not sure you get that. I actually think I think there may be a market for religious items beyond that you could sell. That you could sell the point that they're worth more than what one might pay for them. All I've got to do is establish that there's some. Listen, people buy holy water, don't they? It's water, right?
Yeah.
Jim, right? Mom has holy water, had holy water, I'll bet.
Can't believe how much I've cleared out of that apartment.
So if people buy holy water,
They do.
and they do, right?
In Portugal, we have this little, like, mini Vatican, allegedly Saint Mary.
Mini what?
Like, mini Vatican.
Oh, yeah.
Because Saint Mary appeared there. It's like a mine of money there. People from around the world go there and buy all this, there's like shops all over the place. People buy all kinds.
The first set of these I got, the guy, he's a good friend now. He used to be the Barbary regional person. He went there on a pilgrimage to Medjugorje to get them. And he said, Mike, I'll bring you some back. I said, great. And the legend is that that's the last place the Blessed Mother appeared, and that they turn colors, they change over time. Now this is, I just grabbed this pair because they're the right color now. They change from a darker brown to a light brown, to this color, tannish color. And supposedly they have the power to heal. Now I could tell you stories that I'm serious about, okay? But I won't, because it's law school and we're not supposed to do stuff like that. But when I've told the story before, other people have emailed me or sent stuff in saying, I know, and I agree. And my mother had a pair and she wouldn't sell them either, or whatever. So how many people do I need to establish that there is a market value for some items that goes well beyond what the value is, what the value might be seen as the cost of the baseball, the cost of the road, the cost of the wood, and to be able to sell that to people on a jury? Because all I got to, I mean, right, somehow Jonathan points out I've got to tell them what the value of someone's life lost is to me, where I don't want money, I want the person back, but somehow we say, oh, no, some of this stuff, you got to stop. You just got to stop. We're not going to go down this road.
Maybe it's not the number of people as opposed to where you are, because like she said, in that city, that doesn't cost a lot of money.
Huh?
Maybe it's not the number of people you have to convince, but where you actually are and where you got that is going to cost more there as opposed to where you are now. So if, for example, she mentioned that city of Portugal, if you're there, that costs a lot of money. But here, it's these.
No, it wouldn't cost much there either. It wouldn't beads. They'd probably have
She says
little sweatshops.
water.
Huh?
A lot of people buy holy water.
Oh, yeah.
You have no idea, there's a whole market
Well, if
there.
you're up late at night and you see those commercials on TV, like, I can't believe people actually call in, like, they'll buy, yeah, they'll just sell water on, you know what I mean? Like, oh, holy water, you get money if you buy it, and everything great happens to you, it's crazy.
If you can establish, I think if you can establish a reasonable likelihood that someone would buy it at a certain price, that there's in fact a market for it, you know, anyone, anywhere, you know, then I think that the jury or the fact finder would come to a conclusion that perhaps, you know, that is the value, or somewhere near it.
What if I could establish, provide evidence of that not, and these are not the right ones, but these beads 3 times in the past have had significant healing powers. You don't think that there would be people that would, assuming they could document and verify that, would buy? Well, why not? Why wouldn't that help to establish a higher market value than what, if we went on eBay and looked for rosary beads, what the market is? Now, it sounds a little hucksterish, right? Because I'm playing on people's beliefs and sympathies.
But that's what they do, and you would get more money. I mean, look at any Southern Baptist down there. Like, my buddy lives in Dallas, and there was a minister there that God told him he needed to build a compound for his church. He wound up building himself a $50 million mansion. A reporter down there wrote a story on it, and the reporter got death threats by
I saw
the
that.
congregation.
Well, but see, we don't even have to go that far down south, right? Our churches are full. Our churches are full. People find comfort in it, in the religion, and they find value in it. It's probably better than spending the Sunday morning in a bar room. So why isn't there a market potentially for being able to establish that, well, this is what some people would pay for? Some people wouldn't go near a church. Some people wouldn't go near a religious item. But if there are some that would do it, can't that establish the market value, even though we can disagree? Say, no, Michael, there's no way anyone in their right mind should give you $1,000 for this funky-looking little set of beads. Well, what if I could establish there are some that would? I'm not going to give you $200,000 for a Maserati either, but there are some that will. Right? I'm not sure the market value has to be universal. It doesn't. It can't be. Right? There are things, what do I like? I like ties and striped shirts. I've got more striped shirts than anyone possibly could need, right? But I see another one, I'm going to buy one. But everyone likes, was that a solid color there? So we like different things.
But you can find striped shirts and solid shirts pretty much at every block.
Yeah, you can't find a Maserati at every block, but there's still a market value for it. What'd you say? Sam, what'd you say?
He doesn't buy them in every block though.
No, he doesn't.
So what are you talking about?
It's a point.
On that point, we're going to end. I'll see you next time.